Yes, I salute you all. Thanks for listening and thanks for watching. So basically today we are under the legal methods as a course unit, and the topic that we are going to emphasize more today is the topic of statutory interpretation. This topic is a kind of basically in every aspect of the law, in everything, certain interpretation is so keen. And in this essence, it is basically how courts interpret the statutes. This is not on the advocates or the people, it is on the judges. What the judges apply while interpreting the statute. Realize that there is a lot of interpretation that is done. That's why you may read a section but you fail to understand. But if you go in a case, the case explains it what? All. Because the judge had to interpret what that section was all about. So basically today, we are going to look at the rules of statutory interpretation, of which there are three, but there is the fourth one. However, we have the literal rule, the golden rule, the mischief, and the purposive approach or rule, which is a bit, to a lesser extent, it is less considered, but however much the books also highlight it. So basically, those are the rules of statutory interpretation. And today we are going to look about what? About them. However much, we have also the canons or aids of statutory interpretation, which actually we shall look in the forefront, in the due process of carrying out our previous tutorials online. So basically, I'm going to first take you through the literal rule. The literal rule. As I have said that basically statutory interpretation as the general wording means that this is what courts apply, or this is how court interpret the intention or what the statutes portray. And in this essence, we have the literal rule. And the literal rule, basically, as you hear the word literal, I want actually you be very keen about these rules. The literal, basically, it means that how you see the word. If the word is boy, take it as boy. You get. Actually, I know there are certain scholars that they have what they call a innuendo. I know in front there you realize what is a innuendo. That you have seen a word, but you have interpreted it in the other way around. They call it a innuendo. So in this essence, literal just says that if the word is boy, look at it as boy. If you know that, let me give an example as for me. If maybe I'm called a chimpanzee, if they utter the word, who is chimpanzee? If we are under literal, just say that we don't have a chimpanzee in what? In class. But if you want to bring out the intention, basically you all know that if they say chimpanzee, they're relating to me. But nevertheless, that was just, by the way, just to bring you on board, is that literal, they just look at the plain meaning. It might be the plain meaning or the dictionary meaning of the word. You get, that is literal meaning. That basically here courts are saying that no, if the word is still, we are considering the word still. What does it imply? You get. So basically, we have seen that under literal, we have the case of Sussex Peerage. Under this case, what the court held that for us, while interpreting the statutes, or while we are actually looking at the wording that is in the statute, we look at the plain meaning, the plain or the plain meaning of the word, you get, of the word that is provided in the statute or in the various what case or anything or the matter brought at hand. Actually, even Tindo CJ portrayed still in that case of Sussex Parade, he portrayed that for the intention, what they are trying to bring out, the intention is that what does the word really mean? You get. Also, there is a case of Brutus versus Cousins. Brutus versus Cousins. Here, the court looked at the plain meaning of insult. You get. They said that what does the word insult mean? Could blowing the whistle may qualify to be an insult? You get. So for you, if you are listening here, if I blow a whistle, can that be an insult? Of which, in the plain meaning, it can never fall near to an insult. So basically, when you read the case of Brutus versus Cousins, it portrays that element. You get that. Could the word insult? What does the word insult means? You get. Actually, this is a behavior that is a bit provokes, but me blowing a whistle, can it amount to that behavior that can provoke you? Using the dictionary meaning, it can never, and we know that very, very, very well. And basically, in this essence, that's what they call the literal rule. And also, there is also an interesting case still under the literal rule. The case of Whitley versus Champel. Whitley versus Champel, that was actually, it was whereby it was an offense to impersonate yourself while voting. So this is a person that used the identity or impersonated himself using the identity of a dead what? A dead person. Now the quotation was, at the end of the day, the quotation was, when he was caught and he was arrested for impersonating himself. You get? Now the quotation was, can a dead body amount to be a person? Someone dead. Can he be a person? The answer was no. A dead person is not a person. You all know that he's already a dead person. You get? That's why even if we go to we shall see under whereby theft, yeah, a dead body cannot be stolen because it is not something valuable. You get? So basically, that is the essence that I'm trying to bring, that the person was left free. Reason being that he impersonated, the impersonation was on the dead body, not the person, out of which the law was saying impersonating yourself with a person, of which they looked at the literal meaning of the word person to mean someone that is alive. And then if you open your dictionary there, they will give it to you, the meaning of person. So basically, that is what they call when courts are based on the literal rule. So basically, we are going to look at a few advantages of the literal rule. One of the advantages of the literal rule encourages precision in drafting. Drafting is precise because we don't need to do more research. Look in the dictionary, get the meaning, move on. Drafting, actually, there's also the easy constitutional interpretation. Look at the dictionary, move on. You get? There's no need of you overthinking. Also, you have the advantage that even the judges also, there's time, there is quickness in making judgments. You get? Those are the few that I can highlight, but make more research. When you go to the disadvantages, there is a bit of absurdity, whereby the words that they use or the quotes use, basically it brings absurdity. As I've given you a case whereby the person was left free because he impersonated himself in the identity of a what? Of a dead person. However much what he was doing was wrong, but the interpretation brought absurdity, and the man ended up being let what? Free. So basically, it brings that absurdity, and even it doesn't give room for judges to make their own interpretation. It doesn't give room for judges to make their interpretation. It doesn't give room for judges to give a legal reasoning. Reason that the judges do not think. You get? They just look at the plain meaning, they move on. Look at the dictionary. If it is the Black Dog dictionary, move on. Judges are not in a quotation to make a precedent. Judges are not in quotation to make a ruling concerning the reasoning. Reason being that they are looking at the plain what? The plain meaning. So basically, and also it doesn't give a room for negotiation. You get? A room for negotiation. It ignores the limitation of language. You get? You know, when you're using this language, we have to have a limit. But if we base on language, we end up saying that that person is abusive. You get? So basically, if at the end of the day I may utter a word, and if you follow the literal meaning, realize that maybe you have insulted me, but nevertheless I'm just portraying that what you have done is what? Okay, let me give an example. We have grew up with our parents, whereby a parent may abuse you that you got, you get, mbuzi gwe. Those that listen in Uganda, you know, they basically, in this essence, we don't look that they've told us we are goat, but the meaning that what we are trying to put out is that what we have done is bad. You get? So they are trying to put us in the quotation that we are like a goat, but we are not goats. So that it gives in mind that it ignores the limitation of language if you are to use the literal rule. So basically, also make other what? Other research about the disadvantages of literal rule. So basically, we go to the golden rule. The golden rule basically gives in this essence basically. Yeah, the golden rule basically it is used to probe what the statute should have said or meant rather than what it actually says. Here we look at what the statute would have said, not what actually is stated in the statute. That's the golden. Unlike the literal, for the golden, basically in this essence, what you are looking at, or the golden rule, is that there is the law of reciprocity. The law of reciprocity gives us in the meaning that I give you so that you will give me in return. That's the golden rule. And the golden rule, actually, the courts depart from the literal meaning. You get, and they depart from the literal meaning, whereby the literal meaning may bring what? Absurdity. And they bring out what? The intention. What did the legislator intend? If at all you intended to make impersonating yourself, voting when you're not the person authorized, if you are entitled, then why? Basically, if the statute is maybe a person, let's not concentrate on a person. Let us look at the crime that is what? That is being made. You get? So basically, note that in mind, that courts depart from the literal meaning. And we have the case of Gray versus Pearson. The case of Gray versus Pearson, basically here, court said that the grammatical and ordinary sense of the word is to be adhered to unless it would lead to absurdity. You get? So basically, the grammatical or the original meaning is that it will be adhered to if it does not bring absurdity. You get? And even what you have to know is that the literal rule leaves us to absurdity if at all we are to base on it. But if the golden rule now comes in to remedify that problem, basically. So basically, that you read the case of Gray versus Pearson. That is a good case. And basically, here what you have to know, under the golden rule, it brings less absurdity. Basically, note that in when, and it normally also applies to words that seem to be ambiguous. Get where words are ambiguous, they bring in the golden rule. The advantages, we have even highlighted them through our discussion. That brings the intention of the legislators or the parliament. It is less absurdity. It deals with words that are ambiguous. Among others, even the judges are able to make their legal reasoning. It gives room for judges to make even their law. That's how precedents come in. You get through the legal reasoning. And when you look at the disadvantages, it violates the principle of separation of power, whereby judges are making laws through cases. It violates that principle, and it is less explicit from the mischief. It is a kind of less simplistic. And also it breaches the doctrine. The doctrine, basically separation of power, said, it breaches that doctrine. And also it doesn't provide clear means of existence. You get? Whereby they say that it comes in case there is inconsistency, absurdity. So it doesn't give a clear means of its existence. Basically, that's the golden rule, basically. Not that. Basically, then the third one that we have the mischief. The mischief rule. The mischief rule, unlike other rules, however much it is the most one that courts are bringing in place. That's the mischief rule. Basically, what you have to know about the mischief rule, according to this rule, the problem or the mischief that the statute was designed to redimify should be identified, and the construction made to suppress the problem and advance the remedy. You get? It is the one that is adopted. Basically, they identify the problem or the mischief. After identifying the problem and the mischief, they identify the remedy that they identify uh, the remedy that was supposed to be actually put in place. Then the construction or the interpretation should be made so that they suppress the problem and advance the remedy. Basically, that is the mischief. You get. There is a case of Haydon's case. Haydon case. That is a good case, basically of 1584. I know few of you were born by that time. So basically, 1884. This is a case that was an English case that was a locus classicus by that time. That the judge said that for someone to base on the mischief rule, or for them to base, remember this interpretation is on the judges. Don't misquote me bad. Don't say that an advocate can use it. No, basically in judges while adjudicating their cases. Basically laid down these key elements. First of all, he said that they consider what the law or the act was supposed. They consider the law or the act that was passed, first of all. They identify what was wrong with the law. They identify the remedy. They identify the intention of the what? Of the parliament towards. Then after, they apply the finding or the interpretation in regards of suppression of the problem and advancing the remedy in that case. You get. They look at what the remedy parliament was supposed to solve. You get. And they look at the true reason of the remedy, basically. And basically, under here, the function of the judge is to make such construction to suppress the mischief and advance the remedy. That's all. Those are the key points that must be while we are looking at the rules of what? Statutory interpretation. And the advantages, it chases away absurdity and also suppresses problems. It advances remedies in certain cases. Basically, it is used where there is still ambiguity. Realize that even they can apply the literal rule, but still absurdity, still ambiguity is still around. So it comes in the mischief. It gives freedom of judges and courts to make or to construct statutes. You get. It also looks at the court's objectives. Basically, even the purpose of the courts or the purpose. You get. It gives room for courts also to make laws. It gives room for judges to reason. You get. Nevertheless, the disadvantages under mischief, we have it is a narrow application than the literal and golden. Narrow, basically, it means something that goes deep. If you're not keen, you may get lost on the way. Reason being that it gives a narrow interpretation, something that you have to first you be on it and read it tentatively so that you can understand. So it gives a narrow interpretation. Or basically, for a judge to make a final ruling under the mischief, must also have made research. That's why we have cases of Donald versus Stevenson. That was a narrow application of the judge. You get, and it can only be used to interpret statutes which were passed to remedify the defect in common law. Basically, it limits. It just comes in whereby the statute was made to identify the problem. That's where it is limited. And the courts on occasion go on their way to enable the statute work. Basically here the meaning that sometimes courts leave off track, and they end up putting the statutes aside, undermining the purpose of the statutes. That is the mischief. Basically, I've told you the last one, which is the purposive. However much it is not more so, but it is key. The purposive approach or the purposive rule. As you hear the word purpose, basically here, it is widely used in interpretation also of statutes, whereby they look at the purpose of the legislators. What was their purpose? What was their intention? What was the purpose of this law? So that courts can implement what they have decided, basically. And the advantage that the key that I can discuss on purposive, it looks to the future and the present. That is the purposive approach. It needs understanding why the parliament enacted or passed such law or statute. And it looks beyond the words of the statute. in search of reason of what? Enactment. So it looks beyond. You get. So basically, nevertheless, those are the rules of statutory interpretation. Basically, mischief, sorry, literal, golden, mischief, and purposive. You get. There is no any lawyer that doesn't know these rules. So if you are listening to this video, be keen. Even if listen it day to day, let it be part of you. Because these rules are started in year 3, year 2, year 4, this. Even in practice, a lawyer is listening at the rules of what? Statutory interpretation. But other than that, thank you for listening, and I wish you the best.